Joining us now, retired State Supreme Court Justice Janine Geske, a distinguished professor of law at Marquette. Great to have you here, Justice. We got to ask you about this verdict and the outcome. In your opinion, your thoughts, did the jury get this right?
Well, you know, the jury obviously worked very hard at it. They deliberated for a long time. They reviewed evidence. They looked at the jury instructions. I'm not one to criticize the jury because from the outside, they look like they did their responsibility. You know, this was a very tough case, and frankly, neither verdict would have surprised me. I'm not shocked at this because the state had an uphill battle in attempting to prove that Rittenhouse was guilty under the law.
One of the key moments of the trial is when Kyle Rittenhouse took the stand, usually considered a risky move for a defendant. His attorney, Mark Richards, had some interesting comments about that today, running mock trials before the case. Here, take a listen.
Had to put him on. It wasn't a close call. At certain points, we wondered whether we would put him on. We had a mock jury, and we did two different juries, one with him testifying, one without him testifying. It was substantially better when he testified, I mean, to a marked degree, and that sealed it. But in Wisconsin, if you don't put a client on the stand, you're going to lose, period.
Do you agree with that? I mean, will we see more defendants take the stand after this?
I do not agree with his last statement. Many defendants convict themselves when they take the stand, inconsistent statements. But I'm not surprised they did the mock jury. I thought he was one of the best prepared witnesses I've seen in a long time. He was well prepared, well rehearsed, did not give the state an inch on his cross-examination. And so I think it was a wise move to put him on. But I don't think we're going to see defendants jumping on the stand very often.
Yeah, we'll have to see in that attorney's future cases what he does after making a comment like that. Rittenhouse had two charges thrown out, including a gun charge, in which the judge ruled state statute says it's legal for 16 and 17-year-olds to possess a rifle or a gun. I mean, plenty of kids will be hunting this weekend with guns, but there are already calls for changes to better define when kids can carry weapons. Do you think change is needed in the law?
I think absolutely it is. I think the ruling was correct, and that law was drafted at a time when we were protecting farm kids and kids that are hunting. It was not designed to allow somebody like Kyle Rittenhouse to come with an AR-15 into a community. And because that law, there was that loophole, and I see it as a loophole, the case was properly dismissed against him on that charge. But that statute needs to be rewritten.
It appeared, and you touched on this a little bit, but it appeared the jury struggled with this decision. Any thought on what made this such a tough call?
Yeah, the tough call is Wisconsin's self-defense law. What it had to prove, all that Kyle Rittenhouse had to show was that he believed his life was in danger, and all he had to do was testify, which he did. Then the state had to prove beyond a reasonable doubt that that belief was not reasonable. That is proving a negative. It's a very high burden, and even if the jury had doubts about it, they had to come back not guilty, and that's what made it such a tough case.
Retired Supreme Court Justice Janine Geske, thank you so much for all the time you've given us over the last couple of weeks following this trial.
You're welcome. You're welcome.